Welcome back. Jurors in the murder trial of Lindsay Clancy were sent home early for the day yesterday. That happened after the defense looked to determine if they could call Emily Thorndike as a witness. Thorndike is a TikTok user and licensed clinical social worker who happened to work at the facility Clancy checked herself into before allegedly killing her children. Now, she's posted about the hospital online, saying that it isn't properly staffed during the holidays and was skeptical about Clancy's care.
Joining us now, our chief legal analyst, Khalif Rhodes. Khalif, when a judge is determining if a witness can be listened to, I mean, relevance, expertise, like how do you determine that this is going to be a credible witness?
You're all over it. And so first, let's paint the picture. This is all happening outside the presence of the jury. And so they will have a basically mini question and hearing right there in front of the judge. Defense goes first, kind of attempts to lay the foundation for why this person should be an expert, why they should be allowed to testify. So there were a couple things that the judge asked after that process. But I'll say this, and this isn't to make light at the TikTok individual, but when you start with your credentials by listing the high school you graduated from, it's probably going to be problematic. Most of these folks that are testifying are going to be a PhD. They're going to be some type of doctor level, even at the master's at the very minimum. But when she started there, I knew that this was crumbling apart, and the prosecutors kind of hit on that when they started asking questions as well, trying to undermine her credibility. But relevance is where we would probably land on this. Federal Rules of Evidence 403 is where we'd say, is it going to be more prejudicial than probative? And so that's what the judge basically said, that while he appreciated her time, while he understood that she was not someone that was going to get up there and give testimony that was uncredible, he didn't understand or appreciate the prejudicial proportion versus the probative portion. Specifically, she wouldn't be adding anything, and whatever she could add, agreeing with what prosecution said, was something that could be found in the record itself. Prosecutor said, well, why do we need to bring her in to explain how they run as a business when we can just look at the subpoenaed records and show you exactly? And so that would be the better way to do that if we're trying to introduce evidence. They also talked about a number of times about it not being listed as a 5-star location. That was defense attempt to say that because this was some lower tiered residence or location is the why she received lower tiered services. And the judge smacked that argument down, saying at no point in the record was there any type of argument that this was a 5-star location. And so for using her and her TikTok bashing of this location would again be more hurtful than helpful.
There's been so much online speculation in this case, right? And when this happened yesterday, the jury was sent home early. Some of the rumblings were this might be going for a mistrial, and it was because of something that the prosecution did on cross-examination of a defense witness. And I want to play that soundbite for you.
You active member in the Catholic Church?
Yes.
Okay. So you're aware that murder is considered a mortal sin?
Counsel, can I see you over here?
All right, so that's prosecution asking Lindsay Clancy's former mother-in-law about who again was called for the defense as a character witness, and they brought her religion into this, saying, do you know that murder is a moral sin? The judge right on top of that. Why is that question a problem?
Absolutely a no-no, and I'll go back. It wasn't the judge. Defense attorney is the one who said judge object.
Oh, okay.
And then the judge then jumps in and is like, yes, instantly both approach. And so, yeah, you don't want to bring any, I said we don't want to. You're not allowed to bring those types of questions into it where it's calling in the question of the individual's religion. And so, and then you're trying to set the barometer or the standard for some type of accountability or culpability, and that's what that type of question is doing. The standard in this courtroom will be delivered to you by the judge. The judge will give you what the rule of law is, and so if you need to be beyond a reasonable doubt, we are fully satisfied and entirely convinced if that's what the standard is, if this case was in North Carolina, that's what it would be. And so if you're saying that you're now trying to shift or move the goalpost to some other standard of what morality should be or what culpability should be, the judge won't entertain that. And so, yes, rightfully so, struck that down. Now, folks are asking, is this something that should lead to a mistrial? I think it's something that would lead to an opportunity to appeal. I think the judge handled this the right way. And so you can see this isn't the judge's first time conducting a jury trial. The second this is an objection occurs, they approach, the judge addresses it, and then he gives a jury instruction. Listen, disregard what you just heard, strike that from the record, don't consider that for your process when you're evaluating this. That's what you want to have happen. So even if you appeal, the appeal's going to not look at the statement, but look at how the judge handled it, and the judge handled it by the book. So while I don't think it's an opportunity for a mistrial, you can ask for it, I think the judge would deny it. You go and appeal it later, I don't think it's grounds for an appeal. If the judge would have allowed it in, 100% appealable and granted. If the judge would have given an improper statement in terms of how they're supposed to handle it, the jury, appealable. I just don't think that everything that happened is how it was supposed to happen after that bad question.
Khalif, you mentioned what you think of the judge handling that instance there. Again, a lot of people watching this, and everybody likes to try to make an attachment to why did this happen? Oh, this might mean this. When the jury is dismissed early, can you speak to the way that the judge handles, okay, the jury maybe have had too much today, I'm going to dismiss them early. How does a judge handle the flow of a trial and decide whether or not to dismiss a jury early?
And I like the way you stated that. That last portion of your question is the judge has to handle the flow. And so a good judge is going to not micromanage, but manage the game. They're calling balls and strikes. They're not letting things like that question get in when it's not supposed to. So if someone objects, you'll sustain it, and you won't overrule it. But in the situation in terms of time management, some things are allowed they're discussed in the beginning. They're like, hey, we're going to break at noon regardless of where we're at today. I don't want to allow them to start another witness that may be a long 2 days or 1 day. A judge is going to ask those questions to both sides to kind of gauge where they're at with their day. And so this could have been something that was already outside of the presence of the jury. But I suspect after all the things that happened, it was just a good time to stop right there and let's pick it up the next day. They unpacked a lot for sure.
So much coverage and so many people watching this case and where all it goes. I know this is not anywhere near the end of it. Khalif, thanks. Appreciate that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.